Everyone to the Tuesday, September 10th committee meeting, to the meeting of the Albany Common Council's Council Operations and Ethics Committee. I am the chair, Kelly Kimbrough. I'm along with members Hoey, Robinson, and Romero. And today, the topic of discussion will be our local law F of 2024 by Ms. Farrell and a few other members. It's a local law creating a new chapter 50 ethics of the Code of the City of Albany by establishing the Code of Ethics for the City of Albany and Board of Ethics. There will be public comment this evening, although we're lacking in public commenters. So what we will do is basically, yes, we'll do is just have the sponsor kind of run through a brief intro of the legislation, and then we'll discuss it.
Thank you so much. And as I go through it, I, of course, welcome both Jake and Brett to also pipe in or take over at any point. This is something that we've talked about doing for quite some time. So while there are absolutely ethics rules, as we know, in New York State, which do govern all elected officers, I don't want to say that we are without, and there is no ethics for us. We are absolutely governed by ethics codes in New York State. But the City of Albany specifically does not have our own ethics code nor Board of Ethics. And it is something that is, I think, and also other members believe that it is an important thing for us to have. So as we move forward with this, this comes up with a simple framework. There's been a lot of different models that we've talked about over the years. Some of them are very elaborate and some are very simple. I think this is kind of hit in the middle of the two. We want something that is thorough enough to be effective, but simple enough that it's easy for us to follow and not too onerous that we're, chasing down like our third step uncle to fill out a financial disclosure report, which I don't think that actually happens anywhere, but just as an example. So what this does is it establishes a Board of Ethics with 5 members on it, 3 appointed by the council, 2 appointed by the mayor. They serve without compensation. And each member is appointed for 2 years. It also creates a code of ethics, which is a pretty simple thing. It outlines some basic things, which I don't know that we need to go through all of it. It gives definitions on all the different pieces of ethics. We do currently fill out a financial disclosure statement. This will replace that, so we'll have a different financial disclosure statement that will be filed with the clerk. It does create some penalties. It also creates a whistleblower protection. And then it also says that the Code of Ethics has to be distributed everywhere, kind of comes up with some basic things on how you do it. So the Board of Ethics will do advisory opinions, and there's some other functions with it. And I welcome Jake to elaborate and correct anything I might have said incorrectly in there.
Everything was correct. Other things that might be worth mentioning that I think might have been missed. There's recusal standards towards the end of the administration section, and then one of the big responsibilities that the board is going to be responsible for would be advisory opinions in the instance where there are moral and ethical questions where city decision makers can then go and ask about those and get qualified opinions on those. Let's see if there's anything else. I think that covers most of it.
The Board of Ethics will also make recommendations for policy changes for us, too, which, so it is something that, as a council, we could ask for their opinion on different pieces of legislation or situations that may come up to help inform policy, which I don't know that that comes up that often, but I think that it is an important resource for future councils to have.
Okay, with that, Mr. Williams?
Sure, thank you. I submitted some comments to the Research Council earlier in the day and had a chance to discuss them with him briefly prior to the meeting. Some of my proposed edits are just sort of non-substantive things, but I guess just getting to my few more substantive comments. As currently written, the establishment of the board says both that terms shall be at the pleasure of the appointing authority and also for a term of 2 years, and those things sort of conflict with one another. Is it 2 years or is it at the pleasure? So I think just going with simple 2 years would be the better option there, because as with all other appointments, there are, not impeachment, but recall. There's a recall power, or the power to remove board members for malfeasance, things like that. A 2-year term, I think, is the shortest term I can think of any of our boards and commissions. That's not a legal comment, that's just sort of an editorial comment on my part. I don't know.
Yeah, and that's a valid point. I think that that came from, we were looking at so many different municipality codes. I think it was something that just got wrapped in, but I do agree that it's probably not, it's never easy to fill a board. I'm not sure how easy it's going to be to fill an unpaid ethics board.
Correct.
So we might want to keep people as long as we can. So I definitely would be very open to that, and I don't mind at the pleasure of the removing that piece.
And then the other thought is if every term is 2 years, or even if every term is 3 years, what have you, and then we run into the problem of the entire board being up for reappointment at the same time. So we may want to build some sort of stagger into there, as we've done with other boards and commissions. And even to further decrease confusion, we could set all terms to end on, as we've done more recently with other things, December 31st, for example, just to keep terms of office clean, because as I'm sure council staff will tell you, keeping track of all that is often difficult. Had some comments on section 50-2, which I can deal with internally with the Research Council. Yeah, so moving to the definitions under interest. The way this is written, if you're an employee of any firm, partnership, corporation, association that has any business with the city, you have an interest in a conflict. I think that makes sense if you're a shareholder, a board member, a partner, somebody with some sort of decision-making power or some discretion over the actions of that association or corporation. But to simply be an employee, I think that's a pretty strict standard. Think of a situation where, Walmart, for example, challenged their taxes a few years ago. So even if somebody was just a cashier or somebody who stocked shelves at Walmart and they sat on a board or commission, they would have to recuse themselves under the Code of Ethics, or they would have a conflict of interest under the Code of Ethics just simply by being an employee of Walmart. I certainly understand where it's coming from. It just seems a little strict. And that's not even a standard we really hold our own employees to. We require financial disclosures, for example, of common council members, citywide electeds, department heads. We don't require those sorts of things of our own employees, people without discretion and decision-making power. So, maybe we want to limit the definition of somebody with an interest to somebody with that sort of decision-making or discretionary power. And that's something we even kind of recognize in Section D of the interest definition, because it says a corporation of which more than 5% of the outstanding stock is owned by such an officer. So even there, we're recognizing that not every single person who is associated with a company or a firm necessarily needs to have these ethical strictures put in place on them. So maybe just, tightening down that definition a little bit. And I have that same concern with the definition for municipal officer or employee. Excuse me, I don't have much of a voice this evening, which you're probably not complaining about. Under the definition of relative, once again, not really a legal comment here. Stepbrother and stepsister just seems, I don't know if we really need to include that in the definition of what someone's relative is. There's probably a lot of situations.
That is one I'm going to push back on because while I think that this is your experience with having small children, but when you have older children, like there's a lot of situations where it can actually be pretty close. And it's, I do think that step family things can be pretty close, and it is something that if it seems tenuous and there's a lot of situations where this comes up, then it's certainly something that can be changed in the future. But it is, there's a lot of people that you become a blended family. Like there's a lot of families that it's not really like it's technically a stepbrother and sister, but they are like brother and sister. They grew up together. And then how do you,
Yeah, I mean, that's the question with all of this is where do you draw the line? And, some stepbrothers and stepsisters barely know the other exists. And then in cases like you mentioned, it can be very close. So got to draw the line somewhere. My own personal opinion was to not include it, but there's certainly valid reasons to include it as well. And you're the decision maker, not me, so. This one is maybe my biggest concern. Moving on to section 50-6, subsection G, regarding future employment. I don't really know how we enforce this because by definition, once somebody is no longer an employee, they're no longer beholden to this code. So I guess it becomes a question of how do we enforce this against future employees? By definition, they're no longer officers' employees. So I guess the Board of Ethics or the city could go after these people and try to sue them. I don't really know what the recourse would be there, especially because if we look in our violations section, the penalty for violating this code is to fine them up to a maximum amount of 2 weeks of their pay, which once you're no longer an employee, you have no pay from the city. So there may be a way around this. As written, I don't think it really is workable.
So just a quick comment on that language. I think with the intention, be fined up to a maximum amount of 2 weeks of that employee's pay, the interpretation was they could be fined a dollar amount equal to what their pay was, because this only would have applied to someone who was an employee at the time.
Okay, yeah, I mean, that's not how it reads. The language would need to be corrected if that is the intention.
So I'm happy to
and even
edit
still,
it for more
I think that
clarity there.
doesn't answer the question of whether this could even apply to people who are no longer employees, because once you're not an employee of the city, you're no longer beholden to the ethical standards.
True, but it will have been a law that they violated to the city.
Yeah, but the Code of Ethics itself only applies to city employees, so could go back and adjust that to say shall apply to all city employees and all people who have been employed by the city within the past 2 years or something, but as written, it doesn't apply to any former employee.
Okay.
Okay, yeah, let the record reflect that committee member Frederick's also with us, council member Frederick. So you two done going back and forth? Can I kick it around to the?
On that, I just have one or two
Okay,
more
yeah,
brief
no,
comments.
bring it. We're good.
For financial disclosure statements, under subsection F of 50-7 for penalties, I get what this is going for. I think we just need to build in some timing regarding the reminders. So the first reminder says failure to file the financial disclosure statement within 15 additional days after at least one reminder. It doesn't say when that reminder is supposed to go out, and then it doesn't give a timeline for the subsequent reminders. So, say somebody's 5 days late.
Yeah, I would just point out that it's May, so this is not, there's no requirement for any penalty to be given. So I don't know that we need to dig that deeply into it because it is, I mean, there's just a lot of discretion in that. It's not shall give a
There is,
penalty.
but my concern is that, I'm not saying our clerk or any clerk would do this, but there could be a situation, the way this is written, where if somebody forgets for 5 days straight, they could face up to $1,000 in fine because it snowballs so quickly, so.
Okay, that's fine.
That would be my concern there, you know, if we just, again, as you said, it's May, so they don't even have to do this, but if we build in some timelines there that after 15 days they may, and after 5 more days they may, you know, I think that would just reduce the potential of that situation, which again is a remote possibility, but worth considering anyway. And then exceptions and a waiver of penalties may be made under certain circumstances. That's pretty vague. What are the circumstances? Who makes the decision as to whether those may be waived? It kind of insinuates that it's the clerk, but I think we may want to just spell out who's actually making that determination. And I think that is the extent of my comments, other than to also point out, I believe the county already has a Board of Ethics that city issues may be referred to. Not aware of that having happened, but I think that is a possibility it's there for the city and city employees and residents of the city to use. So, you know, do we want to create another level of board or committee that?
So are you recommending that we don't have our own Board of Ethics, but if we have an issue within the city of Albany, we refer it to the county Board of Ethics?
It's certainly something to consider. I mean, as you pointed out, we have a number of boards and committees that we already have difficulty staffing. This is creating another layer that we don't necessarily need. I don't know that, you know, maybe ethics is a city-specific sort of thing, but I think the county probably could fulfill a lot of the...
I think that my personal concern with that would be the appointing of it, in that we would not have a say in who would be on the county. Like, we don't, as far as I know, we have no say on who's on the county Board of Ethics. And not that they, I mean, I'm assuming if you're serving on a Board of Ethics, you've got to be really into ethics. But it's also, I mean, it's something we could discuss, but I personally, maybe it's fine. I don't know. I'm not sure. Is that something, are you aware, is that something that's normally done, that municipalities, like a municipality then just uses, like cedes their ethics to the county?
I don't have statistics on that. I know it's an option that's available. I can look into it more and get back to the committee. You know, I have no real opinion on it, other than my general opinion is to avoid creating new city bodies when we can, just because of the, you know, we have so many to begin with, and it's difficult finding members, and it stretches staff resources to have to staff them. But beyond that, I have no real personal opinion as to whether it makes more sense, you know, other than
I mean, we
let's
certainly
Yeah, that'd be kind of,
discuss it. I don't love that, but
Yeah.
I don't know how other
I guess my other point is
committee members feel.
that's always been an option for us, and nobody's ever used it now, so why do we need our own board, you know, when it's not something that gets utilized even now, but.
Mr. Hoey?
Yeah, I just looked it up. The commission consists of 5 members. 2 are recommended by the majority leader of the Albany County Legislature. 1 is recommended by the minority leader of the Albany County Legislature, and 2 by the county executive. The chairman of the Albany County Legislature may accept or reject recommendations. The chairman of the Albany County Legislature is the appointing authority for the commission. Terms of the commissioners vary and set forth in Law Number 8 for 2011.
Yeah, we're not doing that, so that, if we're going to do it in the city, we'll create our own and deal with our own issues. I mean, for that matter, why not just have a state one, and every lower level of government send it up to the state to...
Well, and that's, I mean, I guess
worked
that
out.
goes back to, because we are already governed by state ethics laws.
Yeah, right. So, okay, next. Ms. Romero.
Yeah, you'll note that I'm already a sponsor. Love this. I think it's a great bill, and I just echo that the city would benefit from their own specific ethics board, where like sometimes it's confusing when there's county or even statewide stuff. People are like, where do I go? Or like what's the actual authoritative body? So love this idea. My two little points that I wanted to just discuss were defining further confidential information. So I'm looking at 50-6 subsection D. And the only reason I say that is like my definition of confidential information might be different than Jake's. Well, I hope it's the same, but you know, which may be different than someone else's. And I think that could just be fleshed out a teeny bit more to have a further definition. For example, explicitly saying things like facts discussed in executive session. But if there are further actual confidential information that should be protected, I think that could be super helpful, especially for like new council members who are coming in and seeing this. You want to make sure it's super clear so they know what they can and cannot do. I think my employment might be an interesting example of employment that would be a potential conflict of interest but would require a disclosure. And I mention that because I'm an attorney in the public defender's office, and I, before I created a insulation from a conflict of interest within my own office, there was the possibility that I could cross-examine Albany police officers. But I created that own insulation within my office to prevent the conflict, but I merely put that out there as a potential, like we don't want no public defenders to be on the common council, right? And so I just, I'm wondering if that type of hypothetical could be or needs to be explicitly written into the law, like other employment. Under E, 50-6 sub E, no municipal officer during their tenure shall accept other employment which shall be in conflict. And then maybe just add language unless the conflict is insulated. For example, like my employment. And we received our own ethical opinions separate for that. I know this is like wonky.
I disagree with that, because then I think adding that language in the insulation, what does that, I think that you're looking for, then you need to further define that. Because I would argue that in insulating that, you are satisfying this.
Okay.
If you didn't insulate it, then you would not satisfy it. And I think that is, I don't know that you need to actually say that. And then, I think in the conflict of interest, it also says,
Okay.
Yeah, I mean, it says shall not do any of those things, which is in substantial conflict with the proper discharge of his or her duties in the public interest, so.
Okay, great, as long as that's covered.
But this is, yeah, I guess that's sort of my concern is, you're a relatively, I don't want to say junior member, but, you're not the one running the office.
Right.
But we're still dealing with these issues, so that's why I'm.
Mr. Iceland?
Yeah, so regarding confidential information, we can certainly add a definition in the definition section for 50-5. I think that would be an easy change to make. As for other employment, I sort of agree that addressing Brett's other criticism might help in addressing that as well. And also, the existence of a board will be there to issue advisory opinions to ensure that you've sufficiently taken the precautions with your other employment.
One more
Thank you.
comment I had briefly, sorry. The whistleblower protection, I mean, there are state and federal protections for whistleblowers. I don't know if we need to include them necessarily in our legislation. It's not to say they shouldn't be in there, but if we're looking for a shorter, leaner piece of legislation, that might be something we could take out.
Normally, I completely agree with you. I hate having extra words where we don't need to. In this one situation, I do think it's helpful if somebody is looking for, that is in a whistleblower situation, to have that, especially because it will be distributed around. Is it something where if somebody is like, I better report this, is it likely that they're actually going to be reading through the Code of Ethics? I don't know, but I do think making sure that, like, I think it's important for that language to be in there, despite the fact I can, completely agree it's likely superfluous, and again, it's always an issue when the state changes their rules and we have to change ours and all of that when but I like having it in there just in,
Yeah.
so it's in a lot of places for anybody that might be in that situation.
Yeah, 'cause you think about the first thing a person that's gonna, make a comment about something like this is, it's gonna be, what's gonna happen to me if you're the whistleblower. You think, what are the consequences? And so to have that in there, explicitly in there, I think would be a good thing. So, but what we'll do is, Mr. Robinson.
Thank you. Just a couple of questions. Dealing with the penalties, my question is dealing with, so if someone is found to be in violation and not filing their reports on time, and let's say they are assessed $250 fee, and they strongly disagree with that fee being charged to them because they have their reasonings for it, what is the appeal mechanism that person can go through to get that adjudicated?
There isn't an explicit process for that, but one of the things that I would point out is that a penalty does not have to be given. Like, it is completely, it is a situation where if there is a penalty that, like, if there's a penalty that is given, I would think it would be highly unlikely that a penalty is going to be given, honestly. Like, it's going to have to be very egregious that somebody isn't doing it. But I would say that the Board of Ethics would probably come up with that procedure. That would be my guess. Brett's got his hand up, though, so maybe he's got a better idea.
Well, yeah, actually, Councilmember Robinson raises a good point, and one I should have thought of. Anytime that a fine is even on the table as a possibility, there needs to be some sort of due process, which is lacking here. So there would need to be, even if, you could just say that they shall have a hearing before the Board of Ethics to contest the fine or something like that, but there does need to be some sort of process, or there needs to be some sort of officer who they can appeal to or make their case to.
Yeah, I think that as this is constructed, a lot of this would have been enforced through litigation, and that would have a built-in appeals process, but I also agree with what Brett said, that a preferable litigation is never the best appeals process, so a built-in appeal to the board would be more efficient and better probably for everyone involved.
Okay, yeah, and it's not just with the, dealing with the penalties, also for, stance of conduct, such as if, it's deemed that my other employment may be in conflict with official duties and I disagree with that, then, I should be able to have some sort of process that will remedy that.
Yeah, that would be the general board opinion, right? Like if you disagree with the city, which has made some determination, you can appeal to the board. They'll put out an opinion on that.
Gotcha. And so we're saying that the board is going to be the final authority on the decisions that are made when it comes to...
The board will be the final authority to decisions made subject to the Board of Ethics, or subject to the Code of Ethics, at least. Obviously, if there was a lawsuit and the courts got in, then they're going to be the final say, as they tend to be.
Yeah, so it sounds like we want to, the intent would be to have the Board of Ethics be the city level authority, and then if somebody still doesn't like the Board of Ethics ruling, then they have the option to file an Article 78 proceeding in court. But at least we have the one level of administrative recourse by having the Board of Ethics determine those things.
I think in me giving support for the legislation, I think there should be some type of appeal statute created inside of the legislation.
I mean, yeah, I guess the initial determination would be made by, at least in the case of penalties, for example, would be made by the clerk, and then the appeal would be to the Board of Ethics.
That's just with the financial disclosure, though. In terms of the other, like the violations, the broader ethics violations, which that's a separate penalty section.
Right, then the Board of Ethics would be the initial arbiter. Generally speaking, there's not going to be, I don't think we build appeal processes into our administrative determinations typically beyond a single level. We could in this case, I guess. I don't know. I mean, you know, you could make it appealable to the mayor or something maybe, but I don't know. Typically it would be, you make your case, in this case, to the Board of Ethics, and then if you don't like that, you would go to court.
Ms. Frederick, did you have your? Gotcha.
Okay, thank you. First and foremost, I think this is a great bill, so appreciate you putting the effort in to bring this forward. I do have a few questions. Please bear with me from just an understanding perspective. So first is the interest definition. And I'm just going to do like a hypothetical, just thinking of like the council and what we do as individuals. A number of us are part of nonprofit boards. And we might sit on the board or might contribute to such, and often, not saying that something significant as ARPA will happen again, but often there are instances where like grants might come in front of the administration and those nonprofits may or may not apply. My question is more so of the granularity of this. So if, for example, we vote on a budget as an individual of which it might include disbursement of grants, of which it might include grants to the nonprofits we sit on the board, are we disclosing that? I'm sorry to keep going down rabbit holes, but I'm just trying to make sure I understand like what level of disclosure we would have to do.
In the financial disclosure piece, I guess I'm not following.
I was interpreting it as standards of conduct, disclosure of interest, and then looking to the definition of interest. So,
I mean, I always do disclose my nonprofit board stuff on our financial disclosure things now, so I don't know.
okay.
I don't see that as.
So I guess more so, I know we disclose that there's a line for paid, there's also a line for unpaid, but we could also just be volunteers of a nonprofit. Like, I'm just curious if that would be considered a violation because we all do a lot outside in the community and have part in different organizations. If we didn't disclose, like at what level do we disclose?
I wouldn't see that as a violation. I mean, if it's something, like if I was doing a very regular, if I was volunteering at an organization that I was not on the board for like 40 hours a week or something like that, I might disclose that because it would be close to employment. But if you're just handing out turkeys for something, I don't think that needs to be disclosed. But I mean, currently we are supposed to disclose all of our work on boards, and we, you know, according to New York State ethics, we should recuse ourselves from any sort of situation where we could impact that. So I'm on the board of the Albany Fund for Education. If the city of Albany was giving AFE a grant for something and I was a voting person on this grant thing, which none of that happens very often, but say the federal government gives us a bunch more money again and that we have another ARPA situation, I would recuse myself from that situation.
And that's more of the example I'm going to. So if we have this situation again, but the legislation that we vote on is for the entirety of the grant distribution, but a small portion might be going to said entity, you would recuse from the entirety of the vote.
So looking at the definition of interest, right, a direct or indirect pecuniary or material benefit, I'm not so sure that that does apply for the, for if it's just nonprofit volunteer work, but this is a question I would look into, or I would ask for an advisory opinion from the Board of Ethics.
I don't see it changing what we do now. In other words, like your volunteer work, your board work, it shouldn't be changed in how you operate now in terms of ethics. So, we currently already disclose if we are on the board of a nonprofit, if somebody was a huge volunteer where it was, and they didn't happen to be a board member, which could happen, they might choose to disclose that, but I also think that would be at the discretion of the person to decide whether or not this did put them in an ethically compromising position because they volunteer so much. But it shouldn't change dramatically what we currently do in terms of our own personal volunteer and nonprofit board work.
Mm-hmm. Okay. Okay, and thank you for that. My next question is, let me just make sure I'm interpreting this right. So when we say disclosure of interest, standards of conduct, B, this separate writing disclosure is this only talking about the financial disclosures, or is this separate, always whenever something pops up that you want to disclose, send it to the clerk in writing?
Can you just tell me exactly where you are?
Yes. 50-6 standards of conduct, subsection B.
That's the disclosure requirement itself.
This is the financial disclosure.
Yes, so it's under the standards of conduct section, which is really the law itself, the meat of it, the things that's actually requiring that you do those things. So, as there's a separate section that I believe talks about the board creating that disclosure form, but that's a section that says you have to fill it out.
Okay, maybe I was thinking of this too broadly. So this is mostly solely focusing on our disclosure forms.
I read them as two separate things, personally. I read the subsection B of 50-6, the disclosure of an interest, to be whenever any organization or any manner in which you have a conflict comes before the Common Council, you have to disclose that. And then separately, I think there is a separate financial disclosure.
So I guess, sorry, so to clarify what I was saying, I guess in my understanding, that would be part of the sheet that that is put out, but it also is, as Brett said, a continuing requirement.
Right, because the financial disclosure is everything you know at the given time when you take office or whatever. And then, I think the standards of conduct disclosure is if, right, if your company comes before a board or something like that.
I should say then that they're related and will likely overlap, but they won't necessarily overlap.
Okay, I see. I just have one other example question, and it's mainly because I do like the topic of ethics, and I'm trying to understand this thoroughly. But on the topic of general disclosure of interest, I know we often are hit with housing legislation in front of the body, and we have members of the council, including myself, I will disclose, that are landlords. So is it something where you should be recusing yourself from housing votes because you might have an interest in that?
I mean, that opens up a very interesting philosophical discussion. Should you recuse yourself from food prices if you eat? I think that some people would certainly argue that that's moral, but I don't think that's certainly not what we're getting into here.
I would not consider that you would need to recuse yourself from a vote on housing unless it was something that, I would say if we were voting on something that impacted a specific, like if we were voting on okaying a pilot that impacted a specific development project that you were part of.
Yes, if we were rezoning one of
Absolutely.
those properties, then yes, you should certainly, that should be
Yes.
disclosed and you
So
should recuse
if
from that.
if it specifically impacts directly your property and not in a general way of like, because we could also then say like, you know, I'm a homeowner, should I really be voting on, you know, the tax?
Correct.
Some of the different tax things because I'm a homeowner, so
I just don't know where that line, but it's more so like if it's specific, so if it's more generalized. If
I would
it's-
say it's
Okay.
specifics.
Okay.
That it's, you know, I think that it could be a larger discussion if you know, remember the guy that came in that had like hundreds of properties in the city of Albany, and he happened to be a council member. People could have feelings about that because maybe he's owned so many properties, but even that, I wouldn't know that that would necessarily violate this. It might just be a topic of conversation for the council that you could ask for an advisory and opinion from the Board of Ethics on.
Yeah, that was kind of the point I was going to make is, you know, I think it makes sense to have ethics legislation, and whether it's county level or local level, a board, but by establishing a code of ethics, these are the types of situations that don't really exist now that are going to exist in the future, is these sort of considerations, these really granular questions that we can sit here and debate, but they're not laid out in the law, and these decisions will need to be made by somebody. I guess that's a Board of Ethics, but then, you know, we have the potential for a lot of situations where council members are going to have to be thinking about these things, asking questions of the Board of Ethics. It's not to say that this legislation shouldn't be passed, but it's just something and, you know, I, again, am all for a less detailed item of legislation, but by having a less detailed item of legislation, it does leave a lot of these open questions that are not answered by the legislation.
And just repeating myself, I'm definitely in support of this legislation. I think it's great. Questions do arise when particularly council members are part-time employment, so we have outside interest, you know. So these are how my questions are coming up. I think that's all I have for now. I appreciate you bearing with me through that.
Okay,
Mr. Robinson?
Okay, it just brought up another question for me regarding the board issuing opinions. Should we put some type of time frame in this legislation that will the board has to abide by? Say, if the council members know we have a vote coming up or something hits the floor that, you know, we need an opinion to be rendered on, we should
Probably
be
a
able
good
to
idea.
receive something.
Yeah, that I would
From the
say
board.
that it would be,
Which sort of further raises the point that the legislation doesn't say how frequently the board has to meet.
yeah, that was something that I thought about too. I mean, I don't know that, in one we have gone through many iterations of this. In one iteration, there was actually several, depending on where you look, some municipalities have a meeting pretty regularly, which I don't know is necessary, but I agree. I think that we should say at least once or twice. I mean, I'm flexible on what it is. If there's nothing that's coming up, they might only need to meet like once or twice a year, but or when they have things come up, like at their discretion, if they have, but it should be driven by turning around an opinion. So we certainly don't want it to be something where if we say that they only have to meet twice a year, we have to wait 6 months because the board might say, well, we don't want to meet yet. So I think that's a really good point to say that it should be turned around within like 30 days or something.
I think there's some complexities to the questions that we're going to ask them. You know, there are some questions that asking them for 2 days turnaround would be a reasonable question. There are some that it might take more than the month, depending on how many people they have, what resources they have to research it, and what time they have. It's just hard to know ahead of time exactly how long those questions will take to answer.
Or, let's be honest, what corporation counsel office resources are, because, I mean, that's, when you boil it down, that's who's going to be doing the legwork on a lot of these questions.
So I mean, is it something that we could say within 30 days? And if if the board has an onerous issue with that, then they have to tell the council within 7 days so the council knows and give a time frame. I definitely would like a time frame if it's something that they can't do it within the 30 days, because just having it indefinite is,
Yeah, I think, my fear is, of course, the worst case scenario, but like we said, that these situations probably will pop up. If there's a vote that needs to happen and, part of my, my job as a, representative is to make sure I'm there to vote in behalf of my constituents. But let's say I have to vote, I vote, and then the board renders an opinion that I had a conflict of interest in that voting decision. Now, how will that affect me as the council member?
I don't know that many of the ethics, I don't think that we're going to be asking often, like I don't know that will be something that will be referring to the board, that if, like a vote on the council. I could see a piece of legislation, to your point, that we might have a piece of legislation that we're like, it would actually be great if we could get an ethics, something from the ethics board to weigh in on whether either language or something like that. But I think an individual council member will not rise to an ethics thing unless it's something where it would have to be a really dramatic situation, and then, there's a lot of other issues. But I agree in terms of, I think it could come up with legislation, and it could be something that we're stuck in a tough situation where we have to vote on this because of something, and we're waiting on an ethics rule. So I think I do agree that the time frame is in there, but I don't know that it'll ever influence an individual council member in terms of that. Because currently we're, we already have ethics, like we already have to abide by New York State ethics laws, and in terms of voting and things like that, and it's never held us up that we haven't had a board of ethics to ask, so.
If it ever did come up, so one thing to note is at the start, these opinions will probably take longer, but as the board is around for more time, they'll have a lot of these questions might not be the same, but they'll rhyme, so they can use essentially the same decision. Maybe when you ask that question the first time, it'll take them 2 months to write an opinion, but then 3 months later, when new council member or whoever shows up and asks the same question, they'll have essentially that opinion ready. If the situation were to come up that a vote had to be taken and that they couldn't issue an opinion in time, I would presumably go and research based on their prior opinions and similar opinions and offer an opinion of my own in their place. Obviously, because I understand that there are time-sensitive votes that you would have to take. But I would hope that if they understood the necessity and the speed that they could make, even if they wouldn't necessarily provide all the reasoning, they could provide shorter rulings.
And as it works now, there is always self-policing as well. So if a council member now has a doubt, they can always recuse themselves. And the way it works now too is our office is available, Jake's available. If there is a question as to whether recusal would be appropriate, that will still be available to council members, and then they can make that determination on an individual basis. But yeah, you're right. These questions could end up before the Board of Ethics, and then we do get into.
Isn't it conceivable that, there are existing boards of ethics right now, right? So would it be possible for our board to rely on an opinion from another, a similar board?
They likely will, especially if there's a single lawyer on that Board of Ethics, then they'll know to look at what other boards of ethics, whenever a question comes up. Albany is a wonderful city, but none of our issues are going to be unique. Every ethics question that comes up is going to be something that someone in some other city has already had to deal with. And I know most other cities in New York State already have a board, so there is a lot to work with. It's just, when there's a new procedure, new people writing in a new format, it might take time to put out decisions that they're proud enough to put their name on at the end.
Okay.
And the board has to, it can't make decisions without actually formally meeting in a notice meeting. So, there is that time element as well that would be a concern. Say if, an item of legislation goes out on a sport legislation on Friday with the intent of it being acted on at not the next Monday, but the Monday after, in the normal course of things, that would be a tight window for the board to meet and render an opinion, even if they already had a canned opinion ready to go.
Okay.
But a lot of times what will happen is Brett and I will meet and we'll render a advisory opinion with the note at the end that says, in the future, the Board of Ethics will provide additional clarity on this and then the vote will happen, and then the board will come out with their opinion, and then we'll say, okay, next time you shouldn't have voted, or something to that effect, if their opinion is different from ours. But I imagine most of the time it won't be, because they'll be looking at a lot of similar research.
Okay. Mr. Hoey, then Ms. Frederick, and then we'll kind of wrap up and try to figure out how we're going to work
Yeah,
through this.
I got a, thank you, Chair Kelly. Yeah, I'm looking at it, and I appreciate the legislation being written up. Again, my question always with legislation, even last night's, what's the problem that we're trying to solve? And from what I'm getting out of the conversation, not that we have people that are acting unethically now, but maybe in the future they might. So I want to go take a step back here. I've belonged to organizations and we use Robert rules. I know here we use Mason's rules. But there's Robert's rules, and then in organizations I've been in, it's Bobby's rules, where things are loosey-goosey. And for something like this, I think we really got to nail this down before we pass anything. Now, one of the things, because this was the thing that was bugging me, but you guys kind of answered it with the frequently asked questions. We should come up with a guideline for this board. These are going to be the questions that are going to be asked. And right away, tonight, we've heard a lot of them. What about if you do this, that? So that's the one thing that I'd like to see is frequently asked questions so the board can look at it and then they can judge. I do have a question too for
Can I
you,
just-
Jake. As far as training for the board, have you reached out to NICOM? Do they offer like a board of ethics training?
I have not. I can look into that for you.
Sure, that would be great. And then I have another question. These rules shall serve, this section, Article 2 under Chapter 50. These rules shall serve as a guide for official conduct of all officers and employees of the city of Albany. Does that include the mayor? So if we feel the mayor is acting unethically?
Yes, yeah.
Okay.
It includes everyone,
It's
including
everybody.
employee. This is for everybody that works for the city. And that's one of the reasons why I think it's really important, because we should have our own ethics rules and board of ethics for someone that is in an important position like the mayor. Someone that is in an important position like the city treasurer. This is,
Got it. No, again, I was a little bit, I wasn't sure if it was just the council, but I agree, I appreciate that. And I think it's
the
important.
council is absolutely included in this.
Yeah, no, I got it.
Council members are officers, as is the mayor, and then people like Brian, myself,
Again, I
Brett
wasn't
are
sure, but I
employees.
just want to make sure that I got that.
And then to your first point, I certainly think we could add writing frequently asked questions, addressing those as part of the duties itself. So that can be.
I want to circle back on that
Sure.
because I think FAQs are great things. I just don't know that, I wouldn't want to put it in the legislation, but I think it's something that we could request is created because
That could be
especially.
like like a supporting document or something. No
think
problem.
I think
Sure.
it's a great idea, and I would love, especially to have FAQs, I think less for the Board of Ethics and more for the
Internally for
employees,
us.
so that when you get like the code of ethics, that's fine and dandy, but I think, to your point, FAQs would be a lot better with it.
Yeah. So, Brett, you brought up about the Article 78, and believe me, I looked into it when we were fighting 1211. it's around $30,000 to do an Article 78 with all, because of the court costs, filing fees, and then even with an Article 78, if you bring it up and you're found, the court feels that you were capricious and arbitrary on bringing this up, you can be charged even more for the court costs and stuff like that. As much as we can settle outside of court, in my mind, that's the way to go. I don't want to put lawyers out of business. You got to make a living too, but the more gray areas, the more places where, things can come up. So I just wanted to point that out. One of the things, and we all know about it recently with the airport authority or the airport board, they made a decision, it really wasn't transparent. So my question is, when the board meets, is that a public meeting, are they in executive session? So if say they bring me, I get brought up on charges for something, and would the whole world be able to see that because we broadcast stuff on YouTube and stuff?
So it depends. As you've used for executive session, yes, the board will be a board and we'll have open meetings, but the council has often used the personnel exception for executive session, which I imagine would come up a lot in their dealings.
Right, so really, yes, meetings are subject to the open meetings law. They have to be noticed, have to be open to the public, but the board has, the list of reasons they can go into executive session, and if the situation fits in one of those reasons, then they can go into executive session. If it doesn't fit, they can't. So it's just like the council.
Yeah, and again, my concern is that somebody gets brought up, and I mean, we've seen it, somebody gets accused of rape and they're found innocent. That found innocent, a lot of people didn't see it or don't know it. It can taint a person's career. And I do have concerns about, how the due process takes place. And about the appeals. I mean, going back to this article, you said you can do an Article 78. I would like a better vehicle for
I just don't know what other level appeal there would be. I mean,
We had said we were going to put in the specific appeal to the board back in to make sure
Right.
that we stay out of court as much as possible. So I think that will partially address what you said, but as Brett said, there's not really anywhere to go beyond once you've appealed to the board.
Okay.
Right. I guess hypothetically we could give it to another board, like the Board of Zoning Appeals, but at that point I figure they're just going to keep on appealing.
And I will say, in all of the different codes, and there could be one that's out there, I don't remember any specific appeals process, that the real function of this is to have, and just a reminder that right now we don't have this at all. So this is not to say that we've had people behaving ethically or not ethically, but I think we can all think of many situations where it would have been nice to have this.
No, I agree. And I definitely will support some kind of stuff. I just want to make sure that, I don't want to leave it loosey-goosey, is what I'm trying to say, that if there is a problem, and again, we're not going to solve every problem that might pop up in the future, but as much as we know, and I think doing the investigating, looking at other cities' boards of ethics, how many times have they met, what kind of decisions they've made, and I'm thinking NICOM should be able to provide us with that. I'm like 99% sure they do. And I'm throwing a lot of work at you, Jake, but I think it's important that we get that worked out. One thing I'd like to see in the legislation, though, and I don't see it under 50, Article 1, the establishment of the board, that the board members serve until they're replaced. So if you have a
Yeah, that's holdover appointments. That's just default. It would be the case.
that's in state law.
Okay, so that's in state law. Good.
That's true of any
Yeah.
board member, of anything.
And I got a question about the 2 years. Could it be longer? I mean,
It could
I
be.
think it
So
should be
this was,
4 years.
or
I-
5, right?
Yeah.
I think 2 years was taken, maybe it was Yonkers. There was 2 different cities that we were looking at, and I think the language had just come from whatever the other municipality did. But I agree with what has been said frequently here, which is
It's a really valid point that 2 years is short.
give people more
And
time.
along
to-
with
And
the
then you gotta
staggering.
retrain.
Like, I think the staggering is a good idea too, and that
Yeah.
it's, you know, something that we can figure out. I'm sure it's a normal thing in establishment to figure out that, you know, maybe somebody's reappointed. It's also, I mean, I don't think that we should have a term limit on it because, you know,
That was my next question.
yeah, I don't
agree.
think there should be a term limit.
Yeah.
But we have talked about having it might need to be another thing we take care of, but like some sort of function for removing people from boards because,
One does exist. I mean, it doesn't get used,
but we do have one
yeah,
as
it does
a
exist
city.
in the code.
Okay.
Yeah, appointing authority for cause, basically. We would have to have a hearing and figure out what it is that they did wrong. And if that ever comes up, Brett and I will be happy to go over all the
Is that
fun
something we can
details.
reference in the legislation or in the supporting
Well, it's
documentation?
elsewhere in the code. So
And it oversees all the boards, so I wouldn't want to necessarily,
Again, wherever, to make it easier on somebody if they are, in the future, if they're trying to look at something. I think I covered everything. We were talking earlier about recruiting. So I belong to a neighborhood association, and we want to get equipment. We apply for a grant. You know, is that something that, you know, now I'm getting into more specifics, and I guess, you know,
So once again, these are the questions that we want to have a board for so that they can look into it, right? Like my answer for all these will be, it depends, you know. What specifically is your relationship with the neighborhood association? What specifically is the grant for? How does the grant interplay with the neighborhood association itself? You know, I could keep on going about lots of different questions that may affect the balancing of the factors.
Okay.
And as Brett and I have said, if it ever comes up before or if the board doesn't have enough time to render a decision, we're happy to step in and answer those. But I think having a board that can be consistent on these and will cite its own answers and give the same answer from like the same people making the decisions rather than the different legal opinions of individual lawyers like myself or Brett or whoever is corporation counsel in 5 years when the next council member asks those questions will be helpful.
okay,
Miss-
I'll shut up at this point. Thank you.
Good, Ms. Frederick and then Mr. Robinson, it looks like you want to get in there again. And then we'll,
Yeah. This is a quick one, and my last one this time. I'm just curious if we can ask for a very high-level report at the end of the year in terms of how many inquiries they had, you know, time to respond, et cetera, just to see if we have the right, like, makeup and everything.
That's a really good idea to have like a, you know, a wrap-up of the year of some sort.
Yeah.
And I would also want it to include any any policy recommendations.
Yeah. Cool. Thank you.
Mr. Robinson.
Thank you. And again, I'm along the same lines, so I'm sorry. But just, you know, since we're all in part-time employment here, a lot of times we navigate landmines almost on a daily basis, you know, with our full-time employment work. So we just want to make sure that, you know, we're not putting ourselves in any positions, you know, unethical positions. Because this board essentially is going to have some power, and you know we want to ensure that that the power is used, you know, in a manner that they know how to use it, if that makes sense. So my question is, how binding is an advisory opinion? So say such as, you know, if their opinion is in a conflict with another board's opinion. So let's say I have my full-time employment. They rendered that I can, you know, run for office and it's no conflict of interest at all. But then the board may say, well, you know, there may exist some conflicts of interest because of A, B, C, and D.
So how binding is it
and
going to
then-
be?
yeah.
Nothing that we're going to do is going to override the state. So if the state said something different, then I guess that wouldn't be the case. When you talk about like a decision to run like that, you know, it would, so part of what it says here is one of the things that the advisory opinion can be is, if you look at 5012, is the request is beyond its legal purview, which I think they might determine if it was certainly a question of entirely state law and state ethics. So, and I don't think that sort of dodges your question. I'm sorry.
You also, I don't know why you would request an opinion that you already have an opinion on. So I'm not
No,
really sure why one
I'm
would
just-
request.
And what I'm saying is like, you know, say that, you know, we have to make a decision and, you know, it may go to the board that it's a conflict of interest, but we don't feel like it's a conflict of interest because it doesn't conflict with our other employment decisions.
So
If that makes
it's, but why would it go to the board in the first place if you already have an ethical, you know what I mean? Like, you have to, like, you're requesting the opinion from the Board of Ethics. So if you already have a Board of Ethics opinion,
It's when
why would
don't agree with
you?
the opinion, right? Yeah.
What could be mentioning by Councilmember Robinson is like a complaint. Like what if someone else came in and was reporting that type of issue? Like if it's not coming from you, it's not
So
coming
the
from-
opinion's advisory in that they only right, like if I wrote a letter to the board and asked for an advisory opinion, let's say hypothetically council member Novitzin did all these things and then ran for council, you know, they might put out an opinion saying this shouldn't be the case, but they're not going to have the complete set of information, right? They're not. They might have your financial disclosures, but in the opinion that they render in this situation where somebody else puts it in, right? Like theoretically, if they give all the correct information and they put out a decision, and it would.
I mean, I think we're getting into the weeds here. An advisory opinion is just that. It's advisory. It's not binding.
Gotcha. I understand it's advisory, but, you know, once it's put out there, you know, it can affect a lot of things.
Certainly,
You know.
yeah.
So I think that.
I don't,
that
I
is
mean,
what-
I guess from my, like, me trying to wrap my head around something like that happening, let's say that, I will use myself as an example. I work for the Assembly in the committee director of the Environmental Conservation Committee. I have gone through I've talked to every ethical thing. I have stuff in writing, all of that stuff. I feel very confident about where I am ethically. But let's say that council member from the 16th Ward, who is not your son right now, but, you know, Ed Chair is like, he hates me, and he's like, I'm going to push back, and I'm going to put in a complaint to the Board of Ethics because Ginny, let's say I vote on a resolution for a state law, which I have opinions on, like I know that I can do that, and he puts that into the Board of Ethics. In that situation, the Board of Ethics, I would assume that they would take the information from the state level ethics people into their consideration, that it's not, you know, it's not something that's in a vacuum where they're like, I don't know that that would come up.
If it came up with the state, you could certainly appeal to the state board for another opinion. And I think it would be the proper thing to do in that situation, because I imagine any opinion that was asked for in that situation would be out of context and not with the complete information, which is why it would be advisory.
Did you just have your hand up? No?
No, no,
Okay, I looked away and looked back. Okay, so at this point, a lot of information, so we gotta kind of
I
reconcile
think
and
we
put
gotta
together.
amend it and come back.
Yeah, put together what we talked through and then have another meeting, right?
I totally, I think that these are not, when we're looking at like the 2 years to 4 years, that's something I would feel pretty comfortable passing through. And like taken a couple of things out, but I think these are really good changes to it, and I think it's worth changing, like making the amendments and then coming back to the committee.
Okay, so,
Do we know if the administration is supportive of this legislation?
I don't, I mean, I don't know one way or the other.
They've never, I mean, it's certainly, we've talked about it in leadership and things like that. It's not, they've never not been supportive of it. I think it's something that I think it's something that everybody understands the need for it. So it's not, I think that's more of the mindset that it's like, yeah, we should have this, but it's not, it's also not something that they're like tearing everything apart to get done sooner rather than later. But I think it's something that everybody understands, that having our own ethics code is an important thing to do.
okay, so we'll have the sponsor and our staff make the changes, and then we'll reschedule a meeting. So with that, I would entertain a motion to adjourn.
Motion to adjourn.
Second? All in favor, say aye.
Aye.
Aye. Meeting adjourned.